Hello and welcome back to the channel. I'm Professor G. Today we're going to discuss a very important topic when it comes to slavery in the antebellum South. And it deals with a case that actually happened before the creation of the United States. In 1772, there was the landmark case of Somerset versus Stewart. And this happened over in England at the King's Bench. And this set a significant legal precedent concerning the legality of slavery under English common law. And this common law would follow us into the creation of the United States. That's why this case is important. The court was presided over by William Murray, the first Earl of Mansfield, Lord Chief Justice of the King's Bench. Now, he held that a man named James Somerset, who was an enslaved African man brought to England by his owner, could not be lawfully detained as a slave because the law of England did not expressly recognize slavery. So what Lord Mansfield declared was that slavery was so odious, it went so against the condition of human beings, of human nature, it was so repugnant to this idea of humanity, that it could only exist if it was supported by positive law. What that means is there had to be explicit legislative enactments or statutes. So if the law didn't say, you can have slaves, or there can be slavery, then there could not be slavery because slavery is not the natural state or natural condition of any human being. So since no such law existed in England, Lord Mansfield decreed that Somerset was free simply upon setting foot on English soil. Now you can see why this would be a problem, because as the United States developed and became its own separate country, and slavery became the big dividing factor between the antebellum South, the time before the Civil War and up to the Civil War, and the early Republic as well, and the industrializing North that went on to abolish slavery, you could see why this would be a problem. Because if simply setting foot on soil where there was no law to establish slavery made one free, then what happened, let's say, if slaves escaped from a slaveholding state to a free state? And you'll actually see that the framers of the Constitution thought of this inevitability, which it would become, and they put that in the Constitution, where that if any slave did flee from a slave state to a free state, then they would have to be returned to their master, to their owner in the slave state. That was the fugitive slave clause of the Constitution. However, since this common law was adopted by the United States, what happens if a slave owner brought a slave voluntarily into a free state? Let's say they were traveling through that state, or they wanted to stay in that state for a period of time. They were on vacation, something like that. You can see why this idea of slavery needing a positive law to exist would become a very big problem in the development of the United States. And so to counter this, and we'll talk about that issue in a future lesson, what happened when a slave owner voluntarily brought a slave to a free state, because the Constitution for the Fugitive Slave Clause clearly says that if a slave escapes, he has to be returned, right? Which kind of hints at the fact that they knew there had to be a positive law for slavery to exist. But the antebellum South and the jurists of the antebellum South really fought hard against this idea, this decision. Not all of them. Some jurists and some courts in the antebellum South did also agree that positive law was required for the existence of slavery, but not a lot. For the most part, they came up with a different argument. And what I want to cite to you is an inquiry into the law of Negro slavery in the United States by Thomas R. Cobb. Now, Thomas R. Cobb, to show you that this book isn't just some random book written by someone in the antebellum South, he was known as the James Madison of the Confederacy. James Madison being the father of the U.S. Constitution. Thomas Cobb was considered the James Madison, the father of the Confederate Constitution, one of the greatest jurists. He was a Georgia attorney, and he was considered one of the greatest attorneys and jurists and legal scholars in the antebellum South. And in fact, many antebellum court cases that I've cited in a lot of my writings and research dealing with slavery, the judges and justices cite this book. They use it as an addendum of law, for lack of a better term, and they cite to it often. So this, if you were an attorney in the antebellum South and had to deal with a case dealing with slaves, slave ownership, a slave itself, the rights of a master over a slave, anything like that, including a slave owner bringing a slave to a free state, you would use this book to help to create your arguments and to make sure your arguments were on point. So this is a great resource. Now, Thomas Cobb takes a different position than Lord Mansfield and this idea that positive law was required for slavery. And he did something very interesting. He says that there is no requirement for positive law because slavery is a natural thing. It is the best state for someone of African descent to be in. And he parses this argument very carefully, and he does a very detailed job of it. He agrees that in a state of nature, right, and this is if you go back to Locke and even Hobbes, this idea of a world without government, what happens to people, that it is true that in a state of nature, that all people are equal and free. However, he says it does not go against the laws of nature, or the law of nature does not say that people have to remain in that state of freedom. And it is in fact natural for different groups to take advantage of or to enslave other groups, and this is where it gets insane. He even cites that the red ant enslaves the Negro ant, right? That's actually in this book, and he cited that as scientific fact and one of the justifications for slavery. Since it happens in nature, then clearly it can also happen with people. But he takes it one step further. He then asks, well, what are the laws of nature? How do you define the laws of nature? And he pretty much comes to the conclusion that you don't violate the law of nature when you do something to another group of people that actually betters them, that betters their condition. And he then goes on to talk about, for example, if you put a Caucasian in a state of slavery by another Caucasian, it never works. That's his argument, right? Because people on equal levels should not be able to enslave each other. But if one group is superior to another, and enslaving that group actually makes them better, then that does not violate the law of nature because you're doing something to benefit that group. So Cobb then has to go on this long, multiple chapter, pontification and bloviating about how people of African descent are inferior to Caucasians, and therefore if their enslavement makes them better, then that is actually not a violation of the law of nature. It's what should be done to better their condition. And therefore, there's no requirement for a positive law for slavery to exist because it should exist according to nature. And I hope that makes sense, because this gets into how racist the antebellum South really was and how this system was built entirely on this racial hierarchy. And that's why studying this is so important, because in 1865, after the Civil War, when the 13th Amendment, 13th, 14th, 15th Amendments come into play, the equality between the races may have been enshrined in law, but these racist understandings of the world didn't simply stop. People who were brought up, like Thomas R. Cobb, who, don't worry, he didn't survive the Civil War. He was killed. He became a Confederate officer and was killed. But people who survived the Civil War and were brought up reading stuff like this or learning stuff like this didn't simply one day go, oh, slavery's over, now we're equal. No, they still thought that people of African descent were subhuman. So you have to understand their rationale for slavery to understand things like the failure of Reconstruction and how come the legal system continued to remain racist and bigoted for many years after the end of the Civil War and the end of slavery. It's because of people like Cobb and the views that they had, that because Africans were inferior, slavery was a good thing for them because it bettered their nature and they were good in that condition, right? He goes on to say that if you took a Caucasian, for example, a student in Germany, and put them in a library, they would do great in that library. They would study for hours on end. But if you took a Native American and put him in that library, he wouldn't know what to do. He would eventually go crazy and possibly hurt himself or someone else. And his justification behind that was, that's not the nature of the Native American to be sitting in a library. It's their nature to be out on the plains doing whatever he thought Native Americans did. Again, this is a very racist time period, and you have to understand that. So for him, he goes on to write multiple pages about how Africans are suited for labor, they're suited for the field, they do well in this condition. So it not only betters them, but because they excel in it, because we put them in this situation, they do better. Clearly, it's not a violation of the laws of nature. It's something nature intended, therefore no positive laws required for it. He compares people of African descent to domesticated animals, right? He says if you can domesticate a cow or a horse, then clearly it's in their nature to be domesticated. So since we can domesticate, right? Because they looked at Africans and Africans said they were it was barbarism and tribalism, and they were heathens and savages. Since we could take them and domesticate them in effect here, that clearly it must be in their nature. This is where they're better off under slavery of the master race, of the superior race, of the Caucasian. And to show you that, again, here in his Inquiry into the Law of Negro Slavery in the United States, he says, the important truth is before us from history, that contact with the Caucasian is the only civilizer of the Negro, and slavery the only condition on which that contact can be preserved. That the state of bondage, so far from doing violence to the law of his nature, meaning people of African descent, so slavery doesn't actually harm them, right? He says it develops and perfects their nature. And that, in that state, he enjoys the greatest amount of happiness and arrives the greatest degree of perfection of which his nature is capable. And consequently, that Negro slavery as it exists in the United States is not contrary to the law of nature. So because slavery in the United States benefits people of African descent, it is natural. It's not against the laws of nature. And therefore, no positive law is required for it to exist because it is simply a God-ordained thing, and it is the nature of the Caucasian to enslave people of African descent, and that betters their nature and their condition as well. So that's the lesson for today. And again, I really think it's important. I get asked a lot, Professor G, why do you write so much about antebellum slave laws and slave codes? Why do you do this? Where other law professors are writing relevant things and topics of law today, why do I go back to the early republic and the antebellum period and publish works on antebellum slave codes? I know this book backwards and forwards. I can tell you most of the court cases of the antebellum South dealing with slavery, the powers of masters in various states. I'm in Louisiana. I just wrote an article for one of LSU's law journals concerning all of the civil code dealing with slavery in antebellum Louisiana. Why do we do this? Why do I do this? Well, I do this because it's important to understand the racial-based system of slavery in the antebellum South, and that system didn't simply just die in 1865. That racism continued. These judges, these jurists, these justices on state supreme courts and in government didn't stop existing with the 13th Amendment. Many of them continued on in government, in law, in courts, and created Jim Crow laws and the application and enforcement of those laws, all the way up until today, the present day, where many minorities are very distrustful of the legal system because that racial hierarchy system, that bigotry, that racism that existed in the early republic through the antebellum period to preserve the institution of race-based slavery didn't simply end when slavery ended. So again, thank you. Hope you liked the video. Hope you'll share it. Please like and subscribe. I will be posting many lessons on this channel concerning antebellum slave laws, slave codes, how it's relevant today, and really dissecting the foundations of the slave society that was the antebellum South.